Greetings to those who joining. Greetings to those who joining us. We're just admitting further participants.
Become something amazing, like the 2-in-1 benefit that no one can do. This is premium package with no.
Okay, please mute yourself. Those who joining, welcome. Okay, greetings everyone. We're going to start in a minute or two. There's still people coming in the waiting room. So we have a lot of interest in the seminar, and there are also people joining us on Facebook. Right, greetings to everyone who's joining us, both on the Zoom seminar and those who are joining us via Facebook. I'm Professor David Bilchitz, the Director of the South African Institute for Advanced Constitutional Public Human Rights and International Law, in short SAIFAC, which is the Centre of the University of Johannesburg, and we're delighted to host the seminar. We host a range of seminars that take place virtually every week or 2 weeks during the university terms on a range of different topics. And we welcome all of those of you joining us to join us at those seminars. We also have a wonderful event happening at the end of the year where the constitutional law community of the world is coming to South Africa. We're hosting, the University of Johannesburg is hosting the World Congress of Constitutional Law in Johannesburg. And we would definitely welcome many of you to join us at that event, and we'll pop the website in the chat during the course of the seminar. Today's seminar will be chaired by Lauren Loxton, who is a researcher at SAIFAC and has organized the seminar. And following our principles, those who organize get to chair. I'm going to hand over now to Lauren. Also, just before I do, I would like to thank the Konrad Adenauer Stiftung, who is a co-host of the seminar and a wonderful partner continually with SAIFAC, and has also been part of stimulating a new blog that we've created on constitutional law across the continent called African Law Matters. And please follow the blog, sign up to the list. We'll also pop that information in the chat, and some of our presenters today have actually written for the blog. Professor Sibanda, thank you for your contribution, and we very much look forward to you, also those of you who are joining us, letting us know if you'd like to write for the blog, and we would love to host you. So thank you. Without further ado, over to you, Lauren.
Thank you, Prof, for that introduction, and good evening and welcome everyone. Thank you so much to our speakers, and thank you to everyone who's with us today for joining us. I'm sure that what I'm saying is completely uncontroversial when I say that state capture and the work of the State Capture Commission have been at the forefront of public discourse for several years now. There are many important and relevant conversations to be had regarding this report, which already exceeds 3,000 pages in length for those who are counting. So in the light of these complexities, we felt it might be helpful to just provide a very brief high-level summary of the report's findings before I hand over to our speakers.
Webinar on state capture.
I think.
Please continue, Lauren. Someone just was unmuted.
Thank you. Sorry about that, everyone. So as I was saying, Forgive me, these findings that I'm about to summarize are extremely high level because, as I said, the report is extremely lengthy. So this is the best that I can do just before I hand over to our speakers. So the first part of the report, volume 1, delves into the Gupta family's New Age newspaper, the destruction of SAA by former President Jacob Zuma's consigliere, Dudu Myeni, the capture of the SA Revenue Service, and the corruption of the state procurement system through the tender system. The second part of the report deals with the corruption of state-owned entities Transnet and Denel. The third part of the report focuses on the Commission's damning findings on Bosasa. This part of the report details how Bosasa was inherently corrupt and stated that there were prima facie corruption cases against former President Jacob Zuma, ANC chairperson Gwede Mantashe, and former Minister Nomvula Mokonyane, all of whom received benefits from the company that was awarded at least 2.37 billion rand in government contracts between the period from 2000 and 2016. The fourth part of the report delves into the following topics: the attempted capture of the National Treasury, EOH Holdings Limited, and the City of Johannesburg, the Free State Asbestos Project debacle, the Free State 1 billion rand housing debacle, and the capture of Eskom. So aside from these rather broad topics that I've just mentioned that the report findings have covered, it also lists a very specific plethora of people and companies who ought to be prosecuted by the NPA, according to the findings of the Commission. There are too many names for me to list, but what I'm just going to do is I'm actually going to paste a link to a very helpful list that has been compiled by the Daily Maverick, and I'm going to post that in the chat for anyone who's interested. But yes, so thanks for indulging me with that high-level summary of the report. Without further ado, I think it's time for me to hand over to our first speaker of the evening, who is Lauren Kohn. Lauren is presently a PhD candidate and visiting research fellow at Leiden Law in the Netherlands, pursuing a project that is feeding into the governance enhancing endeavor in South Africa. Lauren is an admitted attorney of the High Court with over a decade of public law advisory and legislative drafting contributions to her name. She practiced at Webber Wentzel for several years before transitioning into academia, where she found her vocational passion. She has lectured and convened for over 9 years at preliminary, final year, and LLM level in UCT's public law department. And she's on the editorial board for Constitutional Court Review, a regular media commentator, and has provided technical input for the HSRC on the Constitutional Justice Project. She has also presented at various conferences and colloquia, and tonight we're really excited to have her presenting for us. I was fortunate enough to have been taught by Lauren while I was studying my LLB, so I'm personally very excited to hear what she's got to say tonight. So without further ado, Lauren, I'm handing over to you for about 15 minutes. Thank you.
Thanks so much, Lauren and colleagues. And it's so lovely to see your face again, this time remotely and not in the lecture hall. And yeah, I suppose this is one of the benefits of hybrid and remote working. It's lovely to be here. Thank you for having me. I hope that my sound is okay for everyone and my video function doesn't play up. And if I could just ask all those that are still joining, please just mute yourselves in the interim, but obviously afterwards during question session, feel free to unmute yourself. So yeah, I'm delighted to have been invited to speak, and particularly so by my colleagues here, by Lauren, former student of mine, and my topic that was given to me, which is something that I'm particularly passionate about, and is something that I think weaves its way, I suspect, through the full word of all the many thousands of pages you mentioned, Lauren. I have printed them, but I'm going to be focusing on my section tonight, my topic, which is public procurement, and really the failure of public procurement in the context of state capture. And I've been asked to essentially go narrow but deep, I suppose. So set up the specifics at the outset before my colleagues on the panel pick up where I left off. And in a way, though, I think this is actually quite a broad topic in and of itself. I think you can probably link almost every problem in some way to a failure of the procurement principles and a failure of the procurement system. So I thought just in terms of how I'm going to frame my discussion and how I decided to tackle it, I did what I always tend to do in preparing for a lecture or when thinking about something. I read my section, which is part 1, with a particular focus on volume 3 of the report, but the whole of part 1. And then I read it again, and then I thought, what strikes me in light of my brief? And oddly, what struck me is these components of the alphabet. Procurement is my brief, so P, Q, R, S, T. So if you can work with me there. So I'm dealing with P, S, T, which made me think of post-traumatic stress, if you mix the acronym up, because I actually think we're living in a kind of space of post-traumatic stress as we live in the wake of, and indeed in the continuance of state capture. So those are my themes in terms of my organizing theme, dealing with failure of public procurement in the context of state capture. And then I want to focus on how do we get to the T? How do we transform for good? How do we resolve this issue? And so what are the T words that then came up for me? And in a sense, they permeate this whole, they're going to permeate my organization of my presentation, but they permeate the entire, well, this entire beast, right? And the first T word for me is terminology, which is what I'm going to start with. Then the question of terrain, in particular the regulatory terrain or the legislative terrain. What are we talking about there in terms of structural deficits and or problems? Then the third T word is teams, the people, who's involved here, what, you know, who, I suppose. And then moving to the solution, the post-trauma phase, right? What do we do? And there, the T words that popped up for me were repeated, like things, for example, increased training and teaching to improve technicality and ability, increased transparency, the key role also of treasury, another T word that comes through, the revealing of the truth, the idea of a toolkit, the idea of tangibility, what hard constructive tools can we actually rely on going forward to tackle what's been presented so glaringly and horrifyingly in this report. Just a reminder again, please, to ask if those of you joining, if you could just unmute yourselves temporarily for the feedback. So that's those are the T words that I came up with, and I'm going to try and link back to those as I present. I hope that makes sense to everybody so far. So just to recap, the question is, my narrow topic is public procurement in the context of state capture. So, and then linked to that, what is state capture? And then the T aspects, so post PST in terms of the alphabet, looking at what are the people, the teams, what is the legislative terrain, and what are the solutions for the trauma? How do we fix it? Okay, so in terms of terminology, there's so much that one could unpack there. You know, one has to unpack these notions of accountability, of governance, of oversight, of integrity, of transparency, and how they interlink and or differ. But what I want to get across, first of all, is what actually is this phenomenon that is state capture. And interestingly, although it's tentatively defined in the terms of reference and at the outset in part 1 of the report, I actually found the definition that I liked most in this volume of the report a little bit further on. So I want to start with that as my key defining term in terms of what is this nuisance that we need to tackle and how do we define it. So at paragraph 322, and I think it's page, and then also building on at paragraph 622. But at paragraph 322, it's defined as follows, and I prefer this to the more globular general definition that's used in the beginning in the introductory section, the terms of reference. It's the systemic and deliberate weakening, restructuring of our institutions, the institutional capacity, and various SOEs, strategic appointments and dismissals of key people, the changing of the culture, a pervasive culture of fear and bullying. This is a clear example of state capture. So that is the phrase that's used there. So systematic, deliberate, weakening of institutional structures, weakening of capacity, appointing key people, dismissing people that have been described in varying terms in quotes by certain players in the reports. So it was pre-planned, pre-motivated, and fundamentally orchestrated by the ultimate puppet master, Jacob Zuma. And indeed, if you read the sections in my component of the report that I was asked to look at, there are examples where various people were asked to attend meetings at his residence. There were never records taken. It all goes back to his name. And so it's really quite, the extent of orchestration is massive. And then at paragraph 430, the phrase agenda of looting is used. And that really was the agenda, is how do we go about looting, often using the guise of transformation, particularly in the tender context, BEE. So that is a definition of state capture. At paragraph 21, so in the introduction, it's put as follows: we cannot view this as isolated criminal acts. It's a type of decision-making that predominates. We see fraud and corruption become the order of the day. So something else is at play. It is then that we have state capture. That is what has taken hold of the entity, that has been transformed into an entity. And this is another key nub of the definition, that doesn't benefit the people it serves, but rather the few, so private interests. So if you link that paragraph 21 to paragraph 322, I think we get a slightly clearer definition of what we're dealing with here. Another term, and these terms are used quite loosely in the report: corruption, fraud, undue influence. But then the relevant definitions are put forward at paragraph 722. Fraud is the willful perversion of the truth with intent to deceive and result in actual or potential prejudice to another. Undue influence, a little bit, see, I've been spotlighted, but I hate looking at myself when I talk, so I don't know how to stop that. But in any event, undue influence, when you bring an influence to bear on another and you act in breach of a duty. So again, looser. Let me just change the view, if you don't mind, David and Lauren, to grid view quickly. Okay, so I hope everyone's with me so far. I'm just going to change it to gallery view. Okay, so those are the definitions. That's the terminology. That's the first T. Okay, now, secondly, what are we talking about in the procurement space when we're talking about state capture, and what is public procurement? And if you go further along in this volume of the report, I think a very useful observation appears in paragraph 542, where Zondo notes that procurement isn't, people often mistake procurement as being something administrative you've got to do. You've got to go about getting these, procuring these goods and services, technically to provide for the people of South Africa, and that in doing so, you're implementing laws and regulation and so forth. But the key point to note here is that it's actually a strategic function as well. He says it's a strategic role, it's not merely administrative. And fundamentally what public procurement is about, it's about strategizing how are we going to spend public money in order to deliver services and provide goods to realize the constitutional promise, to ensure social justice fundamentally, and therefore a reconstruction and development, to use older terminology, of our society. So it really is, to use another catchphrase, where the rubber hits the road. It really is where we have administrative action happening all the time. We have implementation of laws. We have potentially the greatest. It's like a boiling pot, just waiting to bubble over. And in fact, that's mentioned at the outset in the volume, part 1, volume 3 of chapter 3 of the report, that it was almost a mess waiting to happen in terms of being open for the taking, partly due to structural deficiencies, but also personalities and party politics. Okay, so that's in terms of the definition of procurement. And in terms of brief terminology that comes up more specifically in the context of procurement in the report, you're going to be looking at words like collusion, confinement, consultants, the 3 C's, and all of the abuse that resulted because of that. Okay, so that's on terminology. Now I want to move on briefly to the question of terrain, right? The regulatory terrain. Why are we in this mess that we're in the context of public procurement playing out, whether it's in relation to SAA, Transnet, etc., etc. And I think it's fair to say, and in fact, I see there's a, I don't want to ruin anyone's anonymity, but I did see a sort of innocuous Vim's iPad 2018, and if it is Advocate Vim Trengo, I'll never forget, he gave a talk not so long ago on the mess that is the procurement regime. And this really came through for me, well, it echoed, I mean, this is a perennial problem, when I read the section of the report. And in fact, Claren and Brunette are cited at the outset in highlighting the problems within this regulatory terrain and why they were so ripe for abuse. But there are some former students here, and I know we're going to have questions afterwards, but I just want to, in case anyone feels the need, to say unmute yourself. And maybe what you could do is just mention some of the laws that feature in the context of public procurement. What do entities need to look at when it comes to public procurement? What do they need to be mindful of? What laws? Just feel free to pop them into the chat or shout out. Anyone? Otherwise, I'm just going to go. No, I can't get rid of the chat. Okay. Can I call on someone? I'm not going to. Okay, I won't go completely rogue, but let me just give you some acronyms for these laws, right? Obviously, the first thing, procurement principles in section 217 of the Constitution. That is in itself problematic. It comes up because often procurement entities, accounting officers, and so forth are unsure on how to balance them. But what they are is that procurement must be done in a manner that is fair, equitable, transparent, competitive, and cost-effective. Then, under that, we've got the PFMA, Public Finance Management Act, under which we've got Treasury Regulation 16A, right? Which, by the way, does not apply to certain entities and does apply to some. Then at local government level, we've got the equivalent of that, which is the Municipal Finance Management Act, because obviously a lot of procuring, a lot of service delivery happens at local government levels. We've got the MFMA, which is Municipal Finance Management Act. Under that, we've also got the Municipal Systems Act, another piece of local government legislation. We've then got supply chain management policies under that. In addition, we've got the PPPFA, the Preferential Public Procurement Act, with its suite of regulations. We've got mention of PAJA, the Promotion of Administrative Justice Act, as I mentioned at the outset. Whenever the state tenders, calls for a tender, and typically whenever it implements that tender, that is administrative action. So we've then got a whole suite of unpacking to do there with the Promotion of Administrative Justice Act. BEE has been brought into public procurement, so there's a direct link to the BEE Act, the Broad-Based Black Economic Empowerment Act. PAPUDA is even mentioned in the suite of legislation, the Equality Act, to use the sort of brief term. PRECA. And so it goes on. And then even when you've got state-owned enterprises, if they're registered, then we've got the Companies Act, and we've got all the relevant company legislation, the King Code, and on it goes. Now, I mean, I'm a lawyer. Most of you here have got some sort of legal training, I'm sure. And even if you don't, this is enough to make anyone pause and think, my word. First of all, this is clearly ripe for abuse because there's bound to be confusion in this massive fragmentation. But secondly, this is confusing and potentially debilitating, right? How do good faith accounting officers at SOEs and so on, how do they act unhindered in the knowledge that they're doing what's right, when even those that purport to do what's right sometimes don't actually know what they're doing because it is just such a mess. And so this is one of the things so this is the terrain theme, right? This is the regulatory terrain, an absolute nightmare, a very, very rich and rich source of legal advice for people, but really very confusing and needs simplification, clarification, and just greater accessibility, precision. So that goes back to the T-word toolkit there. How do we fix that? Okay, I'm going to get to that. I hope, Lauren, I'm doing fine for time for now. So you just let me know, but I'm working my way systematically through. Okay, so that's
sorry, Lauren,
yes.
I just wanted to find out how much longer do you need? Because I think we've had about 15 minutes.
Okay, if I could ask for, would it be fine with the other speakers if I ask for, I'm happy to wrap up in 5 to 7 minutes?
If
5
you
minutes?
can maybe do 5 minutes, that would be great.
Okay, sure. So massive regulatory terrain that's highly complex. Then in terms of players, the technical expertise, we've got National Treasury at the top, accounting officers, and then accounting authorities and public entities. And really the biggest problem in terms of procurement, and then I'll get onto the solutions, Lauren, are what we call a number of things. And if you have a look at the report from page 7, paragraph 736, I'm going to just headline them very briefly for you. Deviations, frivolous deviations from the procurement laws, what we call confinements, so really entrenching monopolies, as we saw in the case of Bain and SARS. Parceling is another term that's used, where you split high value contracts up into little parcels to get each of those below the upper limit that's required to get a deviation. Then another thing is called supplier development partnering. So the abuse of real transformation of BEE partners and really a kind of fronting to achieve high preferential procurement targets. Set asides, special relationships, actually tweaking the request for proposals oneself, as was done in the case of Bain, who was the consultant for SARS, who basically set up its own criteria and then responded to those. Retroactive changes to bid criteria after the award, and the abuse of the use of consultants. That's the mess, right? In the particular mess in the procurement context. And indeed, LCB, thank you for weighing in. Absolute nightmare in terms of regulatory framework. What are the solutions then, very briefly? How do we recover from the trauma? What is the fix? I need another nice T word for the fix. I'm thinking truth, good transformation, transparency. I'm also thinking of toolkit and tangibility. What are the solutions that are actually mentioned in the report? Which brings me to my final component for today. Just give me a moment. Okay, the first thing, and you've alluded to it, LCB, in the chat, thank you so much. The fact that we've gone from one extreme to the next. We moved from having state tender board massive centralization to almost complete decentralization, which has led to fragmentation. And we need to work on that. We need to enhance training. Treasury keeps promising that it's going to, there's going to be training of officials that are in the procurement space. A procurement official, as I said, occupies a strategic and administrative role. It's vital that these people are trained, empowered, upskilled, and have the right integrity and ethics. But timelines keep moving, so we need to literally put the money where the mouth is, so to speak. The other suggestion that's made is changing a possible change to the Political Party Funding Act, because a lot of this money was channeled into use for ANC purposes, elections and so forth. Also, how do we incentivize disclosures, right? An idea of corporate leniency, and I'm not averse to this. So the word that is put out there, or the acronym, is deferred prosecution agreement. I don't like the use of that terminology. I've got my own ideas for terminology there. But how do we incentivize and expedite resolution of this? Because the NPA just hasn't been acting, right? We're slowly seeing some action, but it's been pretty dormant all this time. So how do we fire up the NPA? How do we empower it? How do we equip it? And I've got some ideas slightly different to those that have been presented in the report, but which I'm not going to present today because they're the subject of forthcoming research. But it is it's great that I feel that Zondo has put this out there and said, let's consider this. Let's consider international best practice of deferred prosecution agreements. How do we bring private entities into the loop? How do we ensure we're all on the same page, given the complicity of so many private entities? And there's much discussion about, well, there's this mention of a common charter or code. And then how do we pump up the criminal prosecution? And ultimately, how do we ensure restitution in the form of damages, in the form of return of those lost profits and or just lost money, never mind lost profit, to the fiscus? So that is what I would like to reframe as redress. How do we get that redress on a bigger picture level? And I think that some very useful tools are put forward and very courageously put forward in the report. And just to flag in conclusion for your reference, if you just refer to the index and you have a look at the recommendations from page 700 and, sorry, from page 714, that is where they are all set out systematically, and I'm happy to go through them in a little more detail during question time. So that, just to sum up, is in short what we're dealing with: the terminology, the trauma that it's caused, the terrain that in some ways, the legislative terrain that led to this trauma, the teams or the people at the helm and lower down, pursuant to which we are living through it, and it has come to light, and the plans going forward for true transformation, for truth seeking, for transparency, for the sunlight solution to be reached. So from post-traumatic stress, hopefully to no more stress. And that is me in the nutshell, Lauren. I'm so sorry for having gone slightly over time, and my apologies to my co-speakers. Thanks very much.
No problem at all. Thank you so much, Lauren. That was really, really interesting, and I'm sure everyone enjoyed it. I certainly did. And yeah, your insights were a really great starting point for us to go further now and talk about some more general points on state capture and what the report says thus far. So thank you. And what I should have said to everyone at the beginning is that I'm just going to ask everyone to hold your questions in abeyance until all three of our speakers have gone. We're going to have a nice, hopefully a very engaging conversation at the end. So please just keep your questions in mind. We're really looking forward to having that conversation. Before I move on to our next speaker, I also just quickly wanted to highlight, just please could everyone note that the chat in this call is specifically for professional and appropriate comments. So please just limit your comments to the content of the speaker's presentation. So thank you. So without further ado, I'm now going to introduce our second speaker, Professor Sibanda. Professor Sibanda is a professor and the executive dean of the Faculty of Management and Law at the University of Limpopo. He is a former head of the Department of Criminal and Procedural Law, director of the School of Law, and acting executive dean at UNISA College of Law, where he spent more than 15 years as an academic. Prof Sibanda was once appointed as an extraordinary professor of the UNW Mafeking campus. He is a passionate researcher who has presented papers at numerous international conferences. He holds a Doctor of Laws degree from the University of the Northwest, an LLM degree from Georgetown University Law Center in the USA, and a B.Juris and LLB degrees from Vista University, which is now part of the University of Johannesburg. Prof Sibanda has published several opinions in media publications on important national issues such as the transformation of the judiciary and state capture. And although I haven't had the pleasure of being taught by Prof Sibanda before, as I have with other speakers, I'm very much looking forward to learning from what he's got to say tonight. So without further ado, Prof, over to you. The floor is yours.
Thank you, Lauren. Let me just make myself available. I hope everybody can see me. No, thank you very much, and thanks for inviting me to this particular seminar. And I realize that now Lauren has kept at part of my time, but then I'll try to make up for that kept at time. Having said that, there are a lot of points that were raised by Lauren, which sort of speak to what I'll be addressing, but then in a different way. Because my assignment, or just the general one, was to look into how, as a country, we can move forward to curb the systematic corruption as identified in the state capture report. And then we have had different, instances noted by Lauren, the speaker, and also at the beginning of this particular seminar by Lauren, the chairperson, because we've got two Laurens here. But then Lauren said something about the agenda of looting, while she was giving her own interpretation or understanding of the concept of state capture. And then for me also, the part that I like about the different definitions, that the one that I find to speak more to the way my views to state capture is when you talk about political corruption or systems that tend to distort, the functionality or the functioning of polity. So that is that. And if as a rider, you consider really, as you move forward, we also need to consider maybe as a rider, why should it concern us so much about state capture? There is a lot really to be concerned about. Among those, just to give a brief, example of the ills of state capture as another form of the highest order of corruption. One is to talk about the denigration of the business environment and hollowing of state institutions. And I'm not going to go through, your ESCOM, your DENEL, and many of those. But then it also speaks to how it contributes to human rights violation. When you talk to issues of state capture, it is not only here in South Africa. We have had it in the Eastern European post-communist, countries, your Russia, your Ukraine, the Balkan states, parts of them. Even in Africa, you have had it in Sierra Leone, you have had it in the Democratic Republic of Congo. And I want to speak to that issue, for instance, of human rights violation. At one point, during that part of the state captured by President Kabila, there was sort of a mutiny. The soldiers came and said, no, but they were asking for salary increases. He said to them, but why do you need a salary or money when you've got guns? It's like saying to our state functionaries or officials to say, why do you need to consider yourself bound by or obligated to respect the Constitution and some of the principles when you have power So you see, that is now where we tend to violate, we tend to sort of to muddy the beautiful principles and values that are those relating to our constitution. And another thing, it can drive migration. That is one of the effects of it. And once it drives migrations, South Africans, people in South Africa, people have been contributing to the country. I feel that now I cannot be part of the system that is not going to self-correct anytime. It means now you are divesting the country of some of its valuable human resources. That's one of those. But importantly, that threat to the rule of law, the corrosion of public trust, and unfortunately, as South African public, one can say the public has been a little bit patient with the state of corruption and state capture in general, because we have not seen very popular, cynicism whereby there is action out there. And one is not saying take action, but then action to say we are calling for accountability. So that will be one of those. If I was to ask this particular question, so what are those urgent matters or urgent steps and important ones that needs to be implemented in order for us as a country to go back to the period or to a better period or to recover from the era of state capture? Many people, or will be on the lips of many people will be to say, let's immediately prosecute and then let's really get all the big fish, put them in a fish tank, make sure that now they are never going to escape. But then, in my view, it is not all about, investigation and prison terms. There is also much to do after the investigation, after the prison terms, after the prosecution. Hence, when you look at this particular report, and mind you, the report is just a recommendation to the state president. And the Constitutional Court has pronounced itself on that. And I think Pierre also wrote around the 4th of May, around that particular issue, that it means it can really take long, it can slightly be ignored. So what should concern us, again, in part, is to make sure that now there are improvements in the systems that we have currently, that now the structures that we have are improved, in order for us to give a less chance, a less opportunity, or a less playing ground for corruption and corrupt practices. I always tend to liken Zondo Commission to the one that happened in the early 1980s or late 70s, early 1980s in Queensland, whereby Judge Tony Fitzgerald chaired that particular commission on state capture or corruption within the police system. And what came out there, he said that now, it is, the fact that now nobody must not escape impunity should not be prioritized to overhauling the entire system, like the criminal justice system. So there's a lot that we can do. I'll try really to identify those things that I think that we need to do, that I'm of the view that we need to do as a country or as a system or as a people that want to rid ourselves of these corrupt practices. The first one really is building effectiveness into the MPA and related agencies within our criminal justice system. And why is this particular point important? Even the MPA head herself, Advocate Batoyi, in 2021, I'm not sure of the date there, she warned that now, they are so underfunded as an authority. They are so overburdened in terms of the cases before them. And as a result, they may not be able to prosecute all the cases emanating from the Zondo Commission or from this particular state capture report. And that should be a concern, because most of the cases, or some, they are so interrelated or interlinked if we were to look really very closer to what has been reported in this. So the question then, say, if that is the case, it means we need to reconsider our national anti-corruption strategy. We have the 2020, I think 2030 strategy, which is really premised on very important principles. You talk about transparency, you talk about integrity, you talk about managing integrity, you talk about accountability in the society. And here I'm not going really to talk about integrity in political parties or the current government integrity commissions that are really not assisting very much, because their advisory reports or their pronouncements may be ignored by those that are brought before it. So national anti-corruption strategy really needs to be put in place. We need really to urgent to look at this one. The next one being to let us again think of strengthening the democratic institutions that we have, those that will enable us to prevent political clientelism. And then, yes, of course, and that's again going back to those countries like Bulgaria, Hungary, Macedonia, during those parts, as part of the state capture, we have seen political clientelism taking place. And the state capture, the whole exercise from its first day one, what we have seen people coming before the Chief Justice, now Chief Justice Zondo, we have seen that clientelism, it is also there. You talk about the Guptas, you talk about even some private individuals that are named to have maybe alleged to have benefited from this particular the state of capture in South Africa. But then to do that, it means that you really need to have a very well-functioning, very conscious executive, very conscious government that will say that we need to strengthen these institutions. And once we do that, we need to respect the fact that now they are
I think Professor Sibanda has his internet connection has dropped. There I see he's back.
Professor, are you still there? You with us?
Yes, I think we lost it. I lost you there, or you lost me there. But then I was saying that somebody can say that now, why are you talking about strengthening our institutions? Because institutions are there. We've got laws, we've got the framework, we've got the normative framework for those institutions. It is that now the people that are there are not working. Perhaps one is right, because when you look at a country like the US, the one that I can say has got one of the most well thought, maybe anti-corruption laws and framework that can even apply extraterritorially. We have had at one point a person like President Nixon involving her office into a situation of corruption or dispute. So the strengthening also speaks to the people that must be part of those institutions. So we really, as a country, need to start looking very closely. But my question would be, you have institutions such as the Office of the Public Protector, such as for instance, our apex court, the Constitutional Court, that has made a very profound judgment around the issue of state capture. Remember when it says that now, when you have, for instance, the president, you are a constitutional being, and therefore your respect for the Constitution or for this particular document is quite critical. The question is, do we have the executive and the legislature that is also prepared to match what other divisions are doing? I think it is the question that we must start asking ourselves, but then not just continue asking ourselves and put in place measures to make sure that now this happens. Let's also consider, because we want to implement, if it will be implemented, the recommendation, but then who is going to implement these recommendations? That is, I think that's something that we must seriously consider. We need independent minds to be part of that particular bench, that particular body to implement this particular recommendations. Because the only test of the country's commitment to ridding of ourselves of state capture of this particular and related corrupt practices. You can name a lot of them. We need to say that now the people that can implement, they are independent, they are free from any influence. They've got nobody to favor in terms of the implementation. And I don't think at the moment, if those that are currently, expected to implement are fully equipped to sort of extricate themselves from that particular dependency of those individuals that has led to the collapse of our institutions. But then, other point is the issue of accountability and integrity. What is our ecosystem in terms of accountability and integrity? That is something that may be lacking. Our ecosystem needs to be recalibrated. Take, for instance, why don't we at one point consider integrity testing as one of those innovations to make sure that now public appointments that are increasingly politicized are at least, removed a little bit away from corrupt practices. So, but then if we are not going to consider that seriously, come the next 50 years, we will still have the same problems of corruption or corrupt practices, all the other malaise that you can think of. But for me, one of the most important critical intervention is to say, perhaps we need to look at corruption differently. Let's consider. You'll tell me, Lauren, if I'm almost done with. I've expired in terms of time. Let's look at this differently. Let's look at corruption differently. Corruption, it breaks constitutional foundations. It can cause really human rights violation. It tells the world that you cannot get nearer that particular government or country. And therefore, it's a threat to our national security. Security in terms of food, security in terms of work, security in terms of integrity as a country. Why not make it corruption, or particularly grand corruption, a matter of national security interest? And recently, that's what the US has started doing, to say that now, in terms of all the concerns for national security, corruption or grand corruption is one of them. In that way, we'll have a mightier power to fight corruption. There are many, really, to be honest, considerations. Lauren has spoken to those considerations. I'm about to complete this one, really. I could not resist. When you look through the different reports, obviously, there is a call for us to have an agency or a center or a commission that will be responsible as an overarching body to look after or to look at all these acts of corruption. We've had that even through different, State of the Nation addresses. President Ramaphosa have said that, we need a commission, we need individuals that will be part of the commission. The question that, or something that we must not forget, otherwise we'll be at the same spot come some 10 years to come. The very same commission should also be subjected to some form of an oversight authority. And I'll tell you why it is this important. In conclusion, I talked about what happened in Queensland in the 1980s, a very good report, a blueprint for the anti-corruption activities. And at the time, the Crime and Corruption Commission was instituted. But then recently, as in the past 2 months, Judge Tony Fitzgerald is being called, to come and now sit as part of as one of the chairperson, where the very same commission that he established or helped establish is being fingered for reversing the gains. Because what has happened is that now the chair of the commission failed to make sure that all that are involved are acting fairly, independently. They are not continuing to make favors. Remember, a commission like this will have a very enormous power, so it needs to be kept in check. Many can be said. Let me just leave it there. Thank you.
Sorry, Prof, to interrupt you on that very interesting point. I'm sure we can explore that further later. Thank you so much for some of your thoughts and for those insights on what we can do or what we need to do in the wake of all these very worrying findings. Yeah, thank you very much. And as I said in the chat, I just want to clarify, I did not mean that you can't comment with your questions while the presentations are happening. I just wanted to alert everyone to the fact that we are going to have oral questions at the end. So if you'd like to speak, you are very welcome to post your question in the chat and post your name in the chat, and we'll ensure that all those get covered later. Yes, but anyway, let me introduce our final speaker for the night, who I also had the pleasure of being taught by at UCT, Professor Pierre, who is the Claude Leon Foundation Chair in Constitutional Governance and the head of the Department of Public Law at the University of Cape Town. He has published widely in academic journals and books on a wide range of constitutional law topics and is the co-editor of the book South African Constitutional Law in Context. He served as Deputy Dean for Undergraduate Studies at the UCT Law Faculty between 2011 and 2013. He is the author of the blog Constitutionally Speaking, which is syndicated by the Daily Maverick, where he writes on legal and socio-political issues and is a regular media commentator on constitutional law matters. He serves on the board of PEN South Africa and on the advisory council for the Council for the Advancement of the South African Constitution. So thank you for joining us tonight, Professor De Vos. The floor is now yours.
Thank you, Lauren, and thank you for SciFac for hosting this event. I will try and be short, which everybody says when I start to talk. I want to say something about, or ask the question, pose the question, at the end of this process, will we be able to say that the Commission of Inquiry into State Capture was a success, that it set out what it, that it achieved what it set out to do? And of course, the question is not an academic one, because we know that commissions of inquiry in South Africa has quite a checkered history. In the apartheid era, the apartheid government often used commissions of inquiry to manage political difficulties and to give the appearance of transparency without actually while making sure that the truth will not come out. The Harms Commission into government-sponsored hit squads is an example of that. And more recently, during the democratic era, the Seriti Commission, whose report was reviewed and set aside by the High Court because it deliberately, so it seems, at least from the outside, set out not to make any adverse findings. It sort of looked away. And there are many ways of doing this. The terms of reference could be restricted. If you appoint the right kind of person to chair the commission, all of those things can be used to manage the system in some way. Of course, we know with the State Capture Commission, its appointment was ordered by the public protector, and then it was made an order of court. And strangely enough, when you look at the terms of reference, they are actually extremely broad. They were promulgated by former President Zuma in January 2018, about 2 weeks before he resigned. So maybe there was some negotiation there, but especially the last term of reference says that the Commission can look at any kind of corruption involving the government and private parties, being guided by the report of the then public protector, but it is quite a broad mandate. On the face of it, from what we have seen so far, the commission, in my view, I was not that optimistic. The quality of the reports, the kind of detail that it contains, some people will say too much detail, is actually quite surprising and remarkable. It's a document that is going to be a historical document that we're going to refer to in the future. And that probably has something to do with the fact that the commission was appointed in the strange way, that the person who appointed it didn't really want to do it and was instructed by the public protector to appoint somebody that was selected by the Chief Justice. All of these things maybe made a difference. So we don't know what is going to be in the final volume or volumes of the report, but so far the kind of content that has been produced is much better than most other commissions of inquiry who were required to look into wrongdoing, make factual findings, and so on. That is not the end of the matter, though. Of course, the first threat to the whole project of the Commission of Inquiry is judicial review. The most prominent or likely avenue of attack has in a way come and gone, and that was that the appointment of the commission was unlawful, because we know from the Sarfu judgment that the power to appoint a commission of inquiry is in the hands of the president, who has to exercise this discretion, not through dictation. This didn't happen in this case. The public protector at the time ordered the president to appoint. So while the second part of the order that she gave, namely that the president has to appoint a chair selected by the Chief Justice, there might still be legal argument to say that because the then president was conflicted, this was acceptable. I think that the appointment was actually unlawful. It clashes with the Sarfu judgment, but because of the time that has lapsed, the review period has now lapsed, and so the Constitutional Court has said in such cases it will normally, or when it's in the interest of justice, even if it found that the appointment of the Commission of Inquiry, in the case of Kajima, it was a tender, even if it's unlawful, unconstitutional, it will not nullify it. It will make a declaration, but the consequences of that unlawful decision will go ahead. So that, I think that ship has sailed. We also know from judgments of the High Court, like Corruption Watch, which set aside the Seriti Commission of Inquiry, that unless there are other circumstances that might implicate the application of administrative law, PAJA, the criteria for review and setting aside is rationality, legality review. And that's not, as we all know, it's not an easy standard to meet. Whether clearly the report as a whole is so comprehensive, it's not going to be reviewed and set aside on the basis that it is not rational. If the commission in some instances overstepped its mandate, which I said was very broad, there could be a legality question there. And of course, individual cases, either the procedure that was followed in terms of our strange kind of rationality, procedural rationality review after the Albert judgment, that could lead to parts of the report, the findings being set aside on individual cases. It's impossible to say, make general statements on that. We will have to see individual cases before the court. So I'm not, I don't think that the judicial review poses a significant threat to the report and to the implementation of the report, to its legitimacy and its legal standing and so on. The big issue is implementation, which Professor Sibanda has spoken about already a little. And there are tricky issues. Of course, the prosecution depends on whether there are sufficient expertise, money, person power to further investigate some of the issues that needs to be investigated, either by the directorate inside the prosecuting authority or by the Hawks. Although the commission has done a lot of the work, it is not court of law. It doesn't work on the same kind of probabilities, and so there needs to be more investigation. I'm sure there will be, in some cases at least, the NPA will be able to prosecute because those who are required to investigate would have done so. But we'll see to what extent. I suspect that the 130 people who have already been named in the report for further investigation and possible prosecution, that it probably won't be possible to prosecute them all because there's just not the money, the resources, the time, the skill to do all of them. And so but that I think is not the end of the matter. The big question is the more political question, which is about the implementation of the recommendations. One must remember that the report is not a legally, can't make legally binding recommendations that the president must implement. The president is the person who appoints, and the president is the owner, in so to speak, of the report. And the implementation has to happen through the executive mostly and the legislature. So it's a political matter. We don't know what all the recommendations are going to be. Some of them will obviously relate to the kind of practices of governance that has become a standard since 1994. And others might, we don't know, but they might include how the governing party itself makes certain decisions, the deployment committee and so on, and also amendments to the way that state-owned enterprises and so on are operated. All of these things are highly contentious and political, and so I'm maybe less optimistic that if those kind of recommendations are made, that many of them will be implemented, or that most of them will be implemented, because there's a tension between the immediate short-term interest of a party in government who has to retain control and it has to govern, and on the other hand, the kind of broader kind of interest that the Commission might want to promote and might want to make recommendations about. There might also be, I don't know, recommendations to change some of the constitutional structure. There's been talk of maybe the way in which the president's power relative to the other branches of government, especially the National Assembly, that one must maybe have to look at that. Yeah, so that I'm not sure that will be implemented. But having said that, there's another issue, and I'm really going to conclude there, that I think is necessary to consider. And that is, for those of us who are lawyers, we like the text. We think that if we pass a law, if we amend legislation, we impose new, say, requirements for procurement, that will fix the problem. Because on paper, it should fix the problem. But there are two problems. Firstly, these changes could have unintended consequences. If you change the way in which SOEs operate, there might be new ways in which the system could be corrupted or captured, maybe by different interests, big business, whatever the case might be. So it's not always clear how any changes or the recommended changes will actually impact on the real world situation. And this is also so because the rules, the policies, the constitutional provisions operate within a system. It is a system of governance. It is entangled deeply in politics. The way it operates depends on many things. Yes, on the text of a specific rule and so on, but also on the way in which the political dynamics, the culture, the political party culture, the relative power of different role players, all of these things are relevant. So even if changes are made, and even if on paper the changes are laudable, one has to be a little bit skeptical or just a little bit careful to reflect on whether those proposals will actually given the other contextual factors, whether those changes will really make a difference. In the end, the one big way in which the whole system could be improved is really more so in terms of how voters react than just fixing on or focusing on legislative amendments, rule changes, and so on. Because and that is for me an interesting thing is to what extent the quite devastating findings already in the report against the governing party as a party and the way it operates against individuals within the party, how that will impact on how voters behave. Because if there is a strong reaction from the public, that more than anything else, that has a bigger chance, let me put it that way, of making a difference and changing the way in which these relationships play out in the long term. The fact that, and for that, it is for that reason, I think, that the attacks on the credibility of the chair of the commission, on the courts who are going to obviously consider some of these matters, either because of review or because prosecutions are going to come before the courts. This is why those attacks have really intensified, or at least one of the reasons. Because if the report and its findings are really credible, if the broader public takes this up and responds to it in ways that punishes the party and the individuals who are said or are found to be involved or silent, involved in or silent about the kind of state capture corruption, then it will make a difference. But if the whole process can be delegitimized and people can be convinced that this is a plot, you know, the usual things, then the likelihood of real success, if you measure this in an ambitious way, is small, or smaller at least. That doesn't mean that the Commission already hasn't done a lot, because as I said in the beginning, it has established this monumental record of a certain period of time about certain ways in which the governance in the country happened, and that is a historical document, and it has already made some impact in the political discourse to some degree. To what extent that will continue or will be intensified, I don't know. So that's all I have to say. I hope I kept within my time.
Thank you, Prof. That was perfectly in time. Thank you so much. And thank you for those valuable insights. That was, yeah, really, really interesting and insightful. We have about just less than 25 minutes left for questions now. So really encourage everyone to engage and to post questions to the chat, or to post your name into the chat, or put your hand up if you'd like to ask a question. I'm going to start by just asking a few questions and just posing them to our whole panel of speakers. I'm just going to read a few questions which are particularly relevant coming off Professor de Voss's observations that he's just highlighted. So I'll pose them, and then if I could just open the floor to the speakers to just give their thoughts. So the first question is from Professor Bilchitz, and he says, relating to Prof Sibanda's point, do the panelists have thoughts on why there was a lack of success in South Africa in capturing the judiciary? This has happened in Poland and Hungary, for instance. How can we strengthen the independence of the judiciary, which ultimately played a central role in the downfall of the Zuma presidency? So that's the one question. And then the other question that we've received so far is, can we trust the officials of the criminal justice system to implement the Zondo recommendations after many of the officials have been corrupted? How do we know that they will not just wait for the outcome of the ANC conference to see if the current president is re-elected? So those are the questions for now. I'm opening this up to the floor again, and if anyone has other questions, please do post them. If I could ask
So can I answer or take a stab at answering the first question, which is a very difficult question to answer?
Please do, thank you.
Yes, I've wondered a lot about why the judiciary has been relatively successful and quite fearless in cases, sometimes maybe a little bit too fearless, because the political science and some comparative constitutionalists would tell you that South Africa, the conditions are not really ripe for the flourishing of a constitutional democracy with a supreme constitution and a powerful constitutional court. It's a highly divided society. The values in the Bill of Rights are not widely shared, and so on and so on. One suggestion would be that the Constitutional Court and the courts generally has actually been a good mechanism, and the judicial review in general has been quite an effective mechanism to legitimize the system, especially among elites. Because it's a safety valve. People who know that they are not going to win within the political sphere, they go to the court. That's why we have lawfare. And so the system is really has been working to some degree for most of the role players, at least in the elite sphere. So that might be one reason why there hasn't been more concerted efforts made to load the courts with people who are not independent, who are not fearless. And the second possible reason is that and people, this might be a bit controversial, but the process through which the appointment of judges happen, it's flawed, quite a bit so. But it does rely on the legal profession. It relies on the idea that lawyers and judges have a certain status. So these people within the system have a vested interest in the courts doing their job. And it does water down the impact and the influence of the politicians. So with the exception of the appointment of the Chief Justice, Deputy Chief Justice, and President, Deputy President of the SCA, the JSC play a role. Yes, there's a lot of politicians on the committee. Sometimes they hold sway, but they don't always. Those who are thought to be aligned to the governing party or to the president or whatever, the outcome that they prefer don't always happen. So there are moderating influences maybe that play a role. There are probably many other reasons.
That's what you could keep in there with that first response. Really, you've basically captured what I would have said. But the other thing, I think the reputation of our judicial system, particularly post apartheid in the democracy, particularly looking at the Constitutional Court, precedes us in such a way that I don't think our judiciary is in a position to let the premium that it has, the integrity, and not to be captured or not really to be working to the whims of other people that are outside of the establishment to rule over them. And for me, that's quite very important, because it means that they need to continue keeping that particular, should I say, shepherding of our constitutional values. And when you look at, for instance, at this issue of corruption, that judgment by the former Chief Justice Mogoeng, really, it opened, should I say, doors to say, you are the judiciary, you need to be headstrong in thwarting or fending off any other efforts to want to influence you. Going to the other question, even about, in terms of the ANC and the November, all the political processes, the question really talks to, and justifiably so, to that question on who should be implementing the recommendation when they come back, and also questions or speaks to the lack or trust deficit that is there, and for a good reason. Hence, it is the question of one saying, we'll wait to see what happens, but then again hoping that the commitments that are made publicly, particularly from the president, that now we are going to implement this. When you look at one of the latest statements some weeks ago or within some months this year, was to say we take the work of the Zondo Commission seriously and implementation is going to happen. I don't know if, but then I can, Lauren, jump to that particular question, but there was a question to say, who should be implementing? Just to quickly link it to this. My view is that it is really the question of you need first expertise. There must be expert people who will be able to help implement this. You know, at the time when it was said, the African National Congress is establishing a task team to make a recommendation to the NEC on state capture. The first question was immediately said that now you are going to have a conflict of interest because you do have individuals in the NEC that are also named or that is alleged to have acted, you know, being part of the state capture that are going to be looking at the same report. How is this going to serve us really? But then coming to the issue of again of expertise. If you have expertise, what can happen is that now it can be appointed, you know, independent board of experts, and this has happened in that the situation of, you know, Côte d'Ivoire, Syrian Arab Republic issues there, whereby the Human Rights Council, what it did, it appointed independent experts, and these people continue monitoring the human rights situation and to see that the country is responding to what it was supposed to implement. So there should be at least a semi-independent body to help at least then implement. It doesn't have to be people that are governing, in my view. Thank you.
Thank you, Prof. Lauren, did you want to add anything, or? I think you might be muted.
Yeah, sorry, I've left my mouse pad at home. I mean, we're literally living through, you know, the consequences of state capture. So I moved my laptop to my office and I forgot my mouse pad. Anyway, just to say, no, look, I want to just pick up on what some of my colleagues have said in response to the questions, which really are broadly, I think, who and how. Professor De Vos mentioned the fact that, you know, this is indeed a commission that was, you know, its sort of genesis is a little bit peculiar, having gone via public protector and then, you know, Jacob Zuma nominated the person and the court confirmed that it indeed needed to be done. So perhaps that's part of its distinctiveness. But I don't know if I'm, and this is perhaps just an instinctive response regarding the who and the how now. The comment regarding, you know, the president ordered it, he can ignore it. I mean, I think, you know, in the wake of the Encounter judgment and our rethinking of these institutions, yes, it is a commission of inquiry. It is not a court. My view is that it's perhaps not quite that simple. I wonder perhaps out loud now if there's not a line to challenge, you know, a decision to ignore it. I mean, the president himself, as Professor De Vos has rightly said, has to, all his actions must also be rational and lawful. Would it be rational to simply ignore recommendations where they spell things out in such great detail, so explicitly, and so in many parts very well reasoned, in some parts there's room for obviously interpretation or clarity, bolstering and so forth. But I don't know if it's as simple as you order it, you can ignore it. I think perhaps there's something there. And just to say, I agree with Professor Sibanda's point, absolutely, about this ecosystem of integrity and the value of a commission, and that itself, or what they call an agency in the procurement context, whatever we term this body, you know, it will just be one of the other checks within the system. It too will be checked. And perhaps this all goes back to David's initial point, which is that ultimately, you know, and this is part of the architecture of our constitution, is the ultimate guardian of the constitution is our constitutional court. And that, you know, that is why certainly judicial review, and Pierre, I must say, you do give me some cause for pause and optimism in your contemplation regarding possible judicial reviews and timelines and so on, because I think it would be a pity were this really mammoth piece of work to kind of either be challenged in a way that undermines its veracity and legitimacy, but also, yeah, because I mean, you alluded to that. You said it's about credibility and it's about legitimacy, and I think some of the somebody in the chat has just recently made a comment about, getting a different commission to oversee this. Yeah, I mean, I think it's, can we just let the current South African criminal justice system do the work? Lauren, I hope it's fine if I'm segueing into this, but I mean, I think this is a legitimate concern. I think the South African criminal justice system, it's been, where has it been? What has been happening? And as Pierre mentioned, I think it was Pierre, or it may have been Professor Sibanda, about the fact that the NPA has been presented with investigations. Oh, it was Pierre's comments about the Special Investigative Unit doing some good work, the Hawks doing good work, it gets put before the NPA, and the fact that we've got 130 or whatever it is people named and shamed. As Pierre mentioned, manpower, resources, and whatever, we need to think a little bit more creatively about how we're going to get some form of redress. How are we going to get money back into coffers so that we can slowly start to see improvements on service delivery? And I agree, Professor Sibanda, this is really, it's about public interest and it's about public security, which is actually, I agree, I think it's part of a national security concern. That's why I mentioned trauma and stress, because I actually think we're living in a state of deep fear, a fear that the state is not working for us. And when the state isn't working for us, how do we really live a full existence? And so we need to, you're right, President Ramaphosa has made a public commitment that we will take the findings seriously. Now he must honor that. It would be irrational, I think, to make that claim and then not follow through on it. The means must achieve or be linked to the end, right? That is the litmus, that is one of the bare components of the litmus test. So we shall see if we can put, if he shall put his money where his mouth is. Lauren, I don't know if that adds and builds off what my colleagues have said, but I think broadly we are on the same, we are ad idem, as they say.
No, thank you so much, Lauren. Thank you for that. And yes, I was actually about to highlight this question in the comments because I think it raises an interesting point. For those who haven't seen it, the question is, how about getting a Commonwealth Legal Commission to oversee the implementation? This thing cannot be left to the current SA criminal justice system. And I think that really just shows an absolute loss of faith, specifically, I suppose, in our National Prosecuting Authority. And that actually raised a question, well, what comes to mind, especially building off what I think all of you really touched on earlier, but I'm thinking specifically of Professor Sibanda and his comment about how we need to strengthen institutions. And for me, the very first institution that came into mind when you said that was the National Prosecuting Authority. And yes, I was just wondering, Prof Sibanda, do you have any thoughts on that, on this idea of getting an independent external body, or the role that they might have in ensuring that the work of the Commission has fruits?
Lauren, I'm for an independent body of experts. But as far as it relates to getting the body external to the Republic, really, I'm not in favor of that. Because that's exactly what we are trying to prevent, because then you will be, in a way, now capturing perhaps even for a second time the whole country. And I'm not saying that, that Commonwealth body would not do a better job. Otherwise, I would rather use it as a resource to capacitate the body that will be overseeing this. Because the minute we do that, it means really, we have just said, we've got a very strong constitutional court, or the office of the Chief Justice, that has been able to fight away some of this encroachments into the rule of law. But when you do that, we are saying to the world that now we've got nothing working completely. Our judiciary, it is non-existent, and therefore we need you to assist us, take over. I would not really go to that extent, but then I would still use the expertise that are there.
Thanks, Prof. Thanks. That's an interesting, very interesting answer. So thank you for that. I just want to, I see we have a hand up from Irvin Kins. Would you like to ask a question?
No, I want to speak to this thing about the Commonwealth. I mean, I really think this is far-fetched because we've spent so much money on the Zondo Commission already. And we do have internally within civil society, within government departments, within the public sector, within the private sector, we have our experts in this particular country that can take us forward. I mean, just look at the Farnham Commission. We had to get the international panel to tell government how to implement the recommendations of the Farnham Commission. And what we are not focusing on is the time periods that have lapsed since these commissions make recommendations, and then it takes another 7 years before they implement. That is not justice. If we want our country to be on a path where we fix our problems, justice has got to be swift, has got to be seen to be done. And the people that are involved in these crimes, and even if it's classified as political crimes, it must be prosecuted. It must be prosecuted because there's something called the Constitution, and we have to draw in on our own internal expertise. I think we've got to look past getting foreign experts. We can fix our own problems. Thank you.
Thank you so much for that contribution. And I've just seen a comment in the chat room from Elsabe Steenhuisen. And I think that she's agreeing with you by saying currently the legal practitioners who support probono.org and the representation of the vulnerable are working at ground level, securing rights and ensuring the Bill of Rights are adhered to. And we have to deal every day with a broken legal administration in the courts. So I think, yeah, that also speaks to this point that we have people in this country who are doing the good work and who are more than equipped to get the job done. So thank you for that. Just want to quickly ask Professor De Vos if he'd like to weigh in on this, and then time is almost up. So then I'll just ask one final question before we close.
Thanks, Lauren. Yes, Evan, I strongly agree with you that there's been, I mean, the Marikana Commission is an example of how even the not so definitive findings, or the findings that were definitive were not acted upon. No police officer has been prosecuted or for the involvement in Marikana. And it's really important to remember that we live in a constitutional democracy. The Constitution creates institutions. That system, getting external people outside of the constitutional structures, I feel is profoundly problematic. It's undemocratic. So if we don't trust the government of the day to implement, then we have to vote the government of the day out. If we feel that the hawks are not doing their job, or the prosecuting authority, we have to put political pressure on those institutions. Having a quick fix and trying to get somebody else in, I don't think in the long term I don't think it's a principled position, and I don't think in the long term it is a wise thing to do, because we vote for political parties, they form governments, and they have a right to govern. If they don't govern well, it's not really wise to try and circumvent them, to try and fix things, unless the other bodies or institutions are purely there to support and help, where those who have constitutionally the power decide to support this, and there is the political will for it. If there's no political will, no, that's it.
Thank you so much for that, Prof. And yes, unfortunately, this wonderful, very interesting seminar is drawing to a close. It's almost 7 o'clock. So I'm just going to pose one final question to our panel, just for some concluding remarks from each of them. So yeah, I was just wondering if I could maybe have your thoughts on 1 or 2 recommendations on how we go forward from here and how we avoid state capture in the future. Perhaps, Lauren, might you want to go first? I think you might.
Maybe unmute myself. Okay, thanks, Lauren. Yeah, hopefully, I mean, you take me to kind of what I didn't get time to covering, which is, I think, touches on a little bit of what Professors De Vos and Sibanda have already said. How do we go forward? How do we move forward from this? And I'll limit my answer to my brief for the purposes of the talk. I think there are some seeds for good development in the Zondo report part 1 in terms of public procurement. I think a root of a lot of this evil is indeed in the public procurement space. I don't know if, I mean, obviously legislative reform is ideal. It is perhaps a little bit idealistic given the one-party dominant culture that we have. But I think if I could just mention what the report mentions and perhaps my preliminary view on it in response to you. So just to get it across for the benefit of the audience, ultimately what they propose, what I see is kind of like a pyramidal structure which sort of modeled in some ways on the setup in the competition law domain. So there would be what they term an anti-corruption agency, which is then shortened to a PACA, prevention of something, anti-corruption agency. You know, either way.
Sorry, Lauren, I don't know if it's just me, but we seem to have lost your sound.
Yeah, we can't hear.
Oh dear, we seem to have lost her.
Sorry,
Lauren, we lost you temporarily there.
Did you? Oh.
Yeah, for about 20 seconds.
Maybe that's a good thing. It just says your internet can't do. Okay, well, look, I really just wanted to get across the fact that I think people should read the recommendations in the report. I think it's a good starting point. And I agree that the solution needs to be homegrown. It needs to be democratic. It may require some fixing of our constitutional architecture and or laws. Certainly, I think in the procurement regime, we need some neatening, we need some training, we need some cohesion there. And I think that the solution proposed, although I don't like the terminology, I don't like the idea of a deferred prosecution agreement. I've got my own sort of terminology in mind, but I think we need to, my view is that we need to look at that. We need to look at how we can, you know, one of the, I think Irvin mentioned, you know, justice delayed is justice denied, I think, as I took away the essence of what you were trying to say. You know, we need to find a solution here and we need to expedite it. And I think the seeds for that development are in the report. And whether or not we term it in such a way is a different story. We can use our own terminology, but there is international best practice that must be tailored to fit our local context, to be democratic, and to fit the bigger framework of our constitution. And that will address many of the problems, I think, in terms of just immediately boosting public confidence, boosting legitimacy, and perhaps even setting things on track for the purposes of the National Prosecuting Authority. That's what I'd like to say. Thanks very much.
Thanks, Lauren. Prof Sibanda, I think maybe we can go in order again.
Well, you know, the idea of deferred prosecution agreements sounds very tempting, but then let's try to avoid that. That does not going to amount to immunity from prosecution and those judicial privileges that we cannot even turn around. So that is the point. The next point also to consider is making sure that we have a bipartisan government or a bipartisan executive / public watchdog or a body that will enable us as we move forward to have a broader oversight as to what is happening around the area of corruption in the country. In fact, when you read that particular strategy, 2020-2030, it talks about involving the public more as a part of the strategy. I'll just leave it there. Thank you.
Thank you, Prof. And then Prof De Vos, if you would like to add your 2 cents.
So I'm a bit of a downer. I don't know if it's just for today, but I don't think you can completely eradicate state capture, especially if you define it broadly as people using money and connections to influence who gets appointed, the decisions government make. It happened before 1994. It will continue to happen long after the Zondo Commission. Of course, the extremity of the kind of state capture that we saw during the term of former President Zuma is extreme. And so whether, to what extent, apart from individuals, how can you fix it? I really don't know. Sort of tongue-in-cheek, I will say, maybe if we eradicate inequality completely, if there was full employment, we create completely new political parties, we fire all the CEOs of all the companies, maybe it will make a difference, because some of these things are, it's structural, it is the hangover from our history and the consequences of colonialism, of bad choices made since 1994. These things, there are no quick fix for them, and they are symptoms really of a bigger societal problem. Yeah, so let me leave it at that. I was half tongue-in-cheek when I said it.
Thank you so much, Prof. De Vos, and thank you so much to all of our distinguished and amazing speakers for your contributions and your valuable insights that you shared with us tonight. I think I've certainly really enjoyed them. So thank you for everything, and thanks to everyone for attending and for your questions. And yeah, on behalf of SciFac, I can say we really value your attendance and your involvement in this seminar. Prof.
And from my side, thank you, Lauren, and thank you to to our presenters. And no doubt this has just laid the foundations for a longer discussion of how to address the problem of state capture, which is a very serious one, taking us to the brink of disaster and many, many troubling issues, which we still, as Lauren has said, we still are facing. So thank you to our presenters, and look forward to a continued conversation. And thank you to everyone who attended. Good night.
Thank you, colleagues. Bye, everyone.